Hi class, Dr. Colson here. I'm going to kind of go over legal research with the history of law and children with disabilities. We're going to kind of go over that today and hit some high points. So I want to share my screen with you in just a minute. First off, nobody had any questions that they had wrote in, and nobody's attended yet. So we'll just kind of play it by ear as that comes along. This week, you learned about some of the important cases and things that have shaped America, especially when it goes to children with disabilities and how we treat them, and also about how we treat individuals in general. So let me get to one of the main components. I'm just going to kind of share my screen with you, and then I'm going to talk with you about some things. There's a couple of major cases that I want to go over with you today. The first is the Brown versus the Board of Education, 1954. So in 1954, the U.S. Supreme Court issued a landmark civil rights decision in the Brown versus Board of Education. In Brown School, children from 4 states argued that segregated public schools were inherently unequal and deprived them of equal protection of the laws. The Supreme Court found that African American children had the right to equal educational opportunities and that segregated schools had no place in the field of education. Also, in Brown, the Supreme Court described the emotional impact that segregation has on children, especially when it has the sanction of the law. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. The effect of this separation on their educational opportunity was well stated and in other cases. Also, after the Brown decision, parents of children with disabilities began to bring lawsuits against their schools because of their exclusion and segregation of students with disabilities. So that sort of led up to the main two that we're going to talk about today, which is Park and Mills. So in the early 70s, there were 2 cases were catalysts for change, and that's the Pennsylvania Association for Retarded Children, which is what we call Park, versus the Commonwealth of Pennsylvania, and Mills versus the Board of Education of District of Columbia. So Park dealt with the exclusion of children with mental retardation from public schools. In the subsequent settlement, it was agreed that the educational placement decisions must include a process of parental participation and a means to resolve dispute. So Mills also included the practice of suspending, expelling, and excluding children with disabilities from the District of Columbia public schools. The school's primary defense in Mills was the high cost of educating children with disabilities. And the genesis of this case was that 1, failure of the district to provide publicly supported education trained to plaintiffs and other exceptional children. And 2, excluding, suspending, expelling, reassigning, and transferring of exceptional children from regular schools without affording them due process of the law. So that's kind of what came about that. So Congress went ahead and ended up putting forth a law because of these cases, and they read that these were unconstitutional. We couldn't do this. This was not right for children. So Public Law 94-142, which is the Education for All Handicapped Children Act, better known as AHCA, was initiated, and this law intended children with disabilities would have a right to education and to establish a process by which state and local education agencies may be held accountable for providing educational services for all. So this is really the first law that's came into effect. This is, okay, you know what? We are going to require you to service students, and you have to provide them with a free, appropriate public education. Actually, the FAPE part came along a little bit later, but then IDEA was reauthorized and came about, and that was actually Public Law 94-142 was reauthorized as IDEA in 1990, was reauthorized again in 1997, and then we're in the final revision right now, which should have another one. But IDEIA, which is the Individuals Education Disability Improvement Act. So that just kind of gives you just a little background on those. I just want to make sure I clarified that for you so you understood what those were. Also, ESSA, the ESEA, not ESSA, ESSE, is the Elementary and Secondary Education Act. This was to address the inequity opportunities of underprivileged children. Congress amended the ESSA to establish a grant program that helps state initiate, expand, and improve its programs. But this was legislation. This is the law. This has been reauthorized as NCLB and now as Every Student Succeeds Act. So this is still into play under several other revisions. But just to kind of give you an idea, these are some of the founding laws and that we still go by today. I hope you have a great week, and make sure you've got all your assignments turned in by Sunday, and I will see you next week. Make sure if you can't join, you write me any questions that you may have. Thanks. Bye.